Welcome to the Inside Story. I'm Billy Hollowell, and today we're talking all about the U.S. Supreme Court. The High Court is slated to take up a number of important cases, reshaping and in some ways shaping American culture. Michael, thanks for joining me today. How are you?
I'm doing all right.
Well, we've got a lot to dive into here. You had a wonderful piece over on the Christian Post recapping and previewing some of the cases that are about to hit the Supreme Court. Obviously, the first one I want to talk about here, it's a big one. It's an abortion case. And obviously, not that long ago, just a couple of years ago, the court heard the Dobbs case and made a decision that overturned Roe v. Wade, and we'll get into all of that. But what is the core of this upcoming case, and how does it differ from that previous legal battle?
Well, last December, the Supreme Court agreed to hear two cases, combined them, that is. They were centered on the core issues of whether or not the U.S. Food and Drug Administration was right to approve the abortion pill mifepristone back in 2000, as well as the more recent loosening of restrictions on access to the drug. In November 2022, multiple pro-life groups, chief among them the Alliance Hippocratic Medicine, they filed a suit to overturn the 2000 approval of the abortion drug by the FDA, as well as the Biden administration's recent loosening of restrictions. Now, a U.S. district judge in Texas issued a stay last April of the FDA's approval of the drug, arguing that it had failed to act on legitimate safety concerns regarding it. Days after that stay was granted, however, a three-judge panel on the U.S. Fifth Circuit Court of Appeals overruled the district court's suspension of the FDA's approval, citing a 6-year statute of limitations. However, the panel did uphold the striking down of the administration's relaxed requirements. And then shortly after that, all of this was in April last year, the Supreme Court released an unsigned ruling that allowed the chemical abortion drug to remain on the market while the legal proceedings continued. Now, unlike Dobbs, the big focus of these combined cases is on the specific regulations centered on the abortion pill, rather than the broader question of whether abortion is a constitutional right.
Yeah, well, I mean, there's so much at stake there, and it's really interesting that the court is going to pick this issue back up. Obviously, that Dobbs decision was massive, and we're still feeling reverberations from that. And so here they are again, reshaping and shaping this issue. So we'll be keeping an eye on that. But there's also another really interesting case. I mean, there's a slate of them, but this particular case involves January 6th and a defendant there in obviously the big debate. Was it an insurrection? Was it not? There's a lot of conversation about that. But this is an interesting case because, again, a lot of emotion around January 6th, a lot of chatter, and here we are in another election year. What's the backstory on that particular case?
The case you're referring to is that of Joseph Fisher. He was a former Massachusetts police officer who faces a multiple count indictment for his involvement in the January 6th Capitol riot. Fisher is specifically seeking to dismiss a charge of obstructing an official proceeding, which, according to U.S. Code Section 1512C, can be punished with up to 20 years in prison. That part of the U.S. Code defines obstruction as involving anyone who, quote, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, impedes any official proceeding or attempts to do so, end quote. In 2022, a district court dismissed the obstruction charge against Fisher, arguing that the statute does not apply to the specific alleged conduct of Fisher because it did not involve a document, record, or other object. However, last year, a three-judge panel of the U.S. Circuit Court of Appeals for the District of Columbia reversed that lower court decision, arguing that there were actually 14 district judges in the jurisdiction of the District of Columbia that had adopted the broad reading of the statute to uphold the prosecution of defendants who allegedly participated in the Capitol riot. So so basically, the Supreme Court's going to see whether or not the district court was correct or the appeals court was correct about this obstruction charge applying to Fisher.
So yeah, a lot. I mean, a lot at stake in that one, in that case as well, because this has been a big talking point, and a lot of people are swept up in this, right? So it's
Yeah.
going to be interesting to see where that one goes. And I mean, my goodness, the issues don't end there. Abortion, January 6th. There's another case, and this one involves guns, and it's on the docket. It's Garland versus Cargill. What is at stake in that particular gun battle?
Well, Garland v. Cargill is centered on whether the federal government can ban bump stocks, which are attachments that enable a semi automatic rifle to function like an assault rifle. The regulation in question was issued shortly after the 2017 Las Vegas, Nevada mass shooting, where a fellow named Stephen Paddock had used semi automatic rifles equipped with bump stocks to open fire on a music festival, killing around 60 people and wounding hundreds more. In response to that tragedy, the Bureau of Alcohol, Tobacco, Firearms, and Explosives issued a rule concluding that bump stocks should be classified as machine guns, which effectively bans them. And it was the Trump administration's Justice Department that actually issued a final rule back in 2018 solidifying this bump stock ban. Now, the litigation, of course, has ensued in response, and the Fifth Circuit and the Sixth Circuit courts of appeal, they have released rulings against the ban. However, the District of Columbia's appeals court has upheld the ban. So as a result, the Supreme Court has taken up the case.
That is very interesting for a number of reasons. Obviously, Republicans tending to be much more on the Second Amendment train, and yet you have this complicated device attached to guns that a lot of different people have opinions on. And after that shooting, it became a very big talking point. And so it'll be intriguing to see what happens in that case as well. Now, I know you covered a few other cases. Is there another one you might want to hit on before our time comes to a close today?
Well, there are actually are, if it's possible, I'd like to focus on two other cases that I think are of
Sure.
interest. First one is another combined case, that of Net Choice v. Moody and Net Choice v. Paxton, which are centered on two laws, one passed in Texas, one in Florida, which allow residents to file lawsuits against social media platforms that they believe wrongfully censored them, especially over political views. Before these laws were passed, the social media platforms have had considerable legal protection from such lawsuits because the current legal precedent argues that social media platforms are not required to adhere to the First Amendment because they are considered private entities rather than public forums. If the high court rules in favors of Texas and Florida, it can open the door for other states to pass similar laws and possibly create a wave of lawsuits, litigation against the likes of Facebook and YouTube over their many documented incidences of censoring conservative speech. The other case I wanted to that has a point of having a potential major impact is that of the Trump campaign's legal challenge against the Colorado Supreme Court ruling, which said that Trump could be taken off of the Colorado ballot. That was the Colorado Supreme Court, as you may recall, they ruled 4-3 that Trump should be removed from the Colorado ballot. And they cited Section 3 of the 14th Amendment of the U.S. Constitution, which prohibits people from holding office who, quote, have engaged in insurrection or rebellion, end quote. So another insurrection question here, basically. And with that one, oral arguments were scheduled for February 8th. And if the high court agrees with Colorado and Trump remains off the Colorado ballot come November, that could lead other states to do the same, which could cause quite the upheaval and uncertainty if Trump gets the nomination and goes on to run as the Republican candidate in November.
Yeah, well, and I think what you have in that case, it's a really flammable case for a lot of reasons, right? Because you had so many people out there saying the election was stolen, and so much debate around that, and people saying, no, the data shows that is not the case. No, that didn't happen. But you push all that to the side, that won't matter anymore because you're going to have a sizable part of the population very upset, feeling as though it was, the election opportunity, or the voting opportunity rather, was taken away from them, right? We're already hearing some of that. And so then you have the other side who says, no, 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 he committed a crime and violated this and should not be on the ballot. So it's really an interesting case. And obviously it affects a lot of what happens in this country, not just this year, but my goodness, the next 4 years potentially, pending.
Possibly.
Right. I mean, so
I was thinking actually mostly of the backlash too. I mean, part of me kind of wonders, if the Supreme Court agrees with Colorado and decides to keep him off the ballot, and other states follow suit, will the backlash be a very successful write-in campaign? And maybe he'll end up winning a state that he might not have had a chance of winning otherwise.
Yeah, that's what makes, I think, that case. They're all really interesting and important cases, but I think that one is the one for me that really stands out because, to your point, this is going to ignite a lot of people on both sides of the aisle.
Hmm.
And look, one side is looking to try to make sure he doesn't run at all, and they're trying everything they can do to make that happen. The other side, they really want to see him run and they want to see him win. And I think probably the part of this that's a little scary for some people on certainly the secular side on the left is that he has been up in the polls over Biden.
Hmm.
So it will be very, very interesting to see what the court has to say. And as you said, those oral arguments are February 8th, correct?
Yes.
All right. Well, we will be staying tuned to that. And once those arguments happen, would love to have you back to talk more about that. Appreciate your time today.
Thank you for having me.
Everyone else, make sure you tune in next week for another episode of The Inside Story and head over to the Christian Post to read all the news you need to see. We will be back next week with another episode of the show. We'll see you then.